Okay, Minister, to return to the subject of my earlier questions on the film industry. First of all, in terms of the copyright and intellectual property rights, the legislation states the following: the right to equitable remuneration conferred by this section shall not be waived by the performer, and the performer shall not assign the right to equitable remuneration except to a collecting society. But the contracts that producers are forcing performers to sign say the following: the artist agrees that the consideration herein constitutes equitable remuneration for the assignment of all rights pursuant to the above and represents a full buyout of all rights. Okay? The producer companies that the state is funding are breaching the rights of writers, performers and actors.
You'll have further opportunity.
Thank you. I believe this question is in relation to the vulnerability of blacklisting and failure to vindicate the rights as employees under EU and national law. But I think you're doing a follow-up to the previous question to Deputy Boyd Barrett.
I'll bring up the blacklisting now in a second.
Of your time.
I will.
In relation to the questions here, and then I will get back to the copyright, I understand that the Deputy's question around blacklisting refers to a situation when a person or persons are denied fair opportunities for work and/or that they are discriminated against for one reason or another in gaining employment. Employment law is the responsibility of my colleague, the Minister for Enterprise, Trade and Employment, and the mechanisms for dealing with allegations of breaches in the employment laws of the state are under his aegis. And these mechanisms are the Workplace Relations Commission and the Labour Court, and they are appropriate forum for dealing with allegations of such breaches. In the event that allegations are upheld, applicant companies for Section 481 must provide details of all WRC decisions relating to the qualifying company, the producer company or other companies in the film group, and where those decisions are a finding against such a company, confirmation that the finding has been followed or an explanation where the finding has not been followed must be provided. I am a passionate advocate for diversity, and as I'm sure you're aware, Deputy, that I would not condone blacklisting or discrimination of any kind. In fact, I've introduced policies that highlight the need for inclusion of all. The work of the Skills Division of Screen Ireland has been particularly important in improvement in hiring practices in the audiovisual industry. Screen Ireland states that open hiring practices have increased to the extent that crew calls are now becoming commonplace for most productions. Crew calls mean that there is an open application process so everyone can apply for crew positions in that production. This is for the industry and those working in it, including those who may be marginalised from minorities or from disadvantaged backgrounds. My department has been informed that 2022 had the highest number of productions providing placements for disadvantaged groups. More broadly, as I referenced earlier this morning, the Safe to Create programme incorporates a zero tolerance of 7 damaging behaviours, including victimisation. Victimisation occurs when there is an adverse treatment of a worker in reaction to a complaint made by employer or worker. It is intended that free online training in tackling bullying and harassment and unconscious bias will be undertaken by all in the audiovisual industry. Training in these areas should further protect the rights of vulnerable or marginalised workers.
And Deputy, there is a question of order here. I understand you asked an earlier related question, but I think it's fair to the Minister that she answers.
Oh yeah, absolutely. Although the point is, as I mentioned earlier on, that if you refuse to sign those buyout contracts, you don't get a job. You are in effect blacklisted. That's the situation, right? But in terms of the specific question, in order to get Section 481, the film producer companies have to sign a declaration that they are abiding by legislation such as the Fixed Term Workers Act and are supposed to notify you of cases. Did Metropolitan Films tell you there was a finding against them by the Labour Court over breach of a collective agreement? I wonder. Does that concern the Minister? Did they inform you that there were 10 different cases on unfair dismissal, 7 to the WRC and 3 to the Labour Court, where the producer company refused to give evidence and said, we're not the employer, because they could hide behind the DAC and therefore refuse even to engage with the court or give evidence when workers claiming unfair dismissal took those cases? I mean, shouldn't the government be looking at the detail of this and examining, is there a major problem? Because I believe there is a major problem.
Deputy, employment practices in the industry have been examined by the WRC, and indeed you had a role in the background on that examination yourself. We constantly monitor the operation of the scheme and work with all stakeholders to bring enhancements where we can. The recent extension of Section 481 is a hugely positive development for the sector and for all those working within it. And without Section 481, productions as diverse as on Colleen Coon and the Banshees would not be feasible in Ireland. The WRC and the Labour Court are independent statutory bodies under the Workplace Relations Act 2015 and the Industrial Relations Act 1946 respectively. They are the mechanisms for regulating employment law in the state. They are under the aegis of my colleague and the Minister for Enterprise, Trade and Employment. Both organisations have statutory powers under which they conduct their businesses, and I have no role in their operations.
Yeah, it's just past the parcel. I mean, this is an email from someone who wasn't even in front of our committee, because they couldn't, their name couldn't be. It just said, "I'd love to chat about the film and TV industry again. Blacklisting, bullying, poor practices are alive and well and happening now in some of the 13 productions that were currently going on in the country." Right? And the people who say things like that are afraid to speak out publicly. Those that did have not worked in the industry since. That's what's going on. Right? Because of the DAC structure, which you are responsible for, right? The producer companies that you give the money, who give an undertaking to comply with all legislation, employment legislation, go into the WRC and say, "I'm not the employer," even though they know who the person is. They know they were employed on a film production where they set up the DAC. They 100% own the DAC, but they say, "I've no employment relationship with that person." Right? And you are letting this happen. And that is a breach of the Fixed Term Workers Act. And I wonder, would you even show us all the notifications or lack of notifications from the film producer companies about the cases that have been taken for unfair dismissal, which is effectively blacklisting?
Minister to respond.
As I said earlier this morning, I know that the Screen Producers Ireland strongly refute any claim of blacklisting in the Irish film industry and demonstrate their commitment to relation with the unions. If you know of a specific instance or of people where it has happened to, it's up to you to make a complaint to the appropriate mechanism, which is the WRC. But you know, and certain individuals are claiming that they have not been able to get a job since. You know, that employment record of any individual is a private matter between the individual and the Department of Social Protection and the individual and the Revenue Commissioners. But if you are aware of a specific incident, it's up to you to make the complaint to the appropriate mechanism, which is the WRC.